Okay, so I'm recording now. I'm Diana Mederos, patent attorney. Thank you for having me. So, what is a patent? Just real fast to recap, it's a limited monopoly on your invention. And your invention is presented in claims in a patent or a patent application. That limited 20-year monopoly allows you to be the sole person or sole entity to make, use, sell, import, export, advertise your invention. However, when that time period expires for your patent, then it becomes in the public domain. That means it's fair game for your competitors, it's fair game for the public. Anybody else can engage in those commercial activities such as manufacturing, selling, importing, exporting. But until it expires, you have control over that product, over that invention. You can license it out. There's no requirement that for you to actually commercialize your invention. However, in order to get a patent, we need to show that your invention was actually made, it actually works. We have to have an enabling disclosure. So, what happens when you have an idea? Are you ready for a patent application? Not always. Usually, I like to take my clients from idea to concept to prototype. Then, at the concept and prototype stage, you're probably ready to start with at least a provisional patent application. A provisional application is an informal application that gets you a disclosure with the information that you have, and it serves as a placeholder that lasts for up to a year until you can claim priority to that application with either a non provisional, the formal application, or for international protection, a patent cooperation treaty or PCT application. And so this is a filing strategy thing that you'll go over with your patent attorney. And that way you can come up with a design timeline, a prototype timeline, a marketing timeline to figure out where it's right to start with the patent process. You don't want to start too early because if you start when you're only at the idea phase and when you actually try to conceptualize it and make a prototype, you realize that what your original idea was may not work. So you have significant changes that need to be made to make it work. However, if you did your patent application too early, those significant changes are not going to be covered under the scope of your provisional application. So the provisional application still is super important for protecting you at the very beginning. And then you take that year, you do some market testing, you raise some funds, you can use that still as patent pending status, and then you gather everything, you're ready to go with that formal non provisional application. Once that's filed, there's quite a bit of a waiting period. Usually, the estimate is about 18 months from filing. That's when you can expect to get your application actually reviewed by a patent examiner. But lately, it's been a bit more. However, we know that there definitely will be examination at some point. So here's what happens during that patent examination. The examiner is going to do a search and is going to evaluate the claims in the patent application against what comes up in the search. And what comes up in the search is known as prior art, meaning information anywhere in the world that's out there that pertains to your invention or relates to it. So then the examiner will either issue a rejection, an objection, or allow certain claims. And the examiner will substantiate the reasoning with certain arguments that are going to be on a technical and legal level. So then your patent attorney comes in and maybe makes some amendments to the claims, looks at the prior art, and creates some explanations to show how your invention is in fact different from the prior art. And then you make the amendments, submit the response, and usually, if all goes well, the examiner will retract the rejections and issue a notice of allowance. Then you get your patent. So, all that time from provisional application or whatever your initial filing date is, all the way through examination, which This whole period could last at least 2 years, sometimes 3, 4, 5 years. This is all the patent pending status. You do not have a patent yet. You get that notice of allowance finally, then you pay the issue fee, it gets issued, and then you finally get your patent. So, what does a patent look like? I'm going to show you some examples, and these are examples of patents that I've gotten granted for some of my clients. And so I'm going to do a screen share. One second, let me get this up. Okay. Okay, on this screen, this is what a typical letters patent looks like. It's not showing? Okay, there we go. Is that showing now? Okay, this is a typical letters patent. So at the top, we have the title here, Device for Revealing a Winner. We have the applicant and the inventor, the application number, filing dates, and then all the rest pertain to specifics for classifying the type of invention at the USPTO and some of the prior art documents that the examiner cited that were pertinent to the invention during examination. And then we have who the examiner was, and then the attorney, agent, or firm that prepared and prosecuted this patent application. So here we have me, Mederos Legal PLLC, Diana Mederos. This abstract is almost like a summary. You read that, you know exactly what the main features of the invention are. Then we have a representative photo or rendering of the invention. This particular invention is a balloon sword for in a balloon sword fighting game. So what is so special about this invention is normally when you're in a sword fight, if you I guess hit the other person, you win, but your own balloon pops, and so you can't really do anything. In this version, the loser's balloon pops while yours stays intact. So that's shown through in the figures, all the different parts. So this is what I mean when we have to disclose the invention to make it enabling, that you actually had something that could work. So this is how specific you have to be. We have all the little parts to make it work. So then we have different views of the figures. We have exploded views to show how the parts fit in with each other. And these are you may think these are very simple line drawings. Yes, and that is the point. We want to keep it as simple as possible for clarity. They're not going to be super technical engineering CAD drawings that a manufacturer would use. Those can be used in a patent application, but usually you want something that's going to more simply represent your invention. This provides some clarity in the scope of what is actually claimed. So you see that there are a lot of pages of figures, of drawings. Then we finally get to the detailed description. And this is part of the specification along with the drawings that help to serve to explain and define what the invention is. So we have the background. This kind of tells us a little bit about what the state of the art is now, what the current problems are, and I'm kind of setting the stage so that the examiner or whoever reads it is going to say, okay, this is what we have now. I see that there are some drawbacks, there are some problems here that can be solved. And then we get to the summary. Boom, this explains how these problems that are alluded to in the background section are solved, and it's solved through this invention that's disclosed. So then we just briefly describe the drawings, and then this detailed description follows what's in the figures in the drawings. And it kind of explains how everything works together, how it can be built, how it can be used. So normally the goal when I draft something is to draft it in such a way to where a person of ordinary skill in the art, in this case a toy maker, would be able to read what I'm writing and be able to reproduce the invention. That's the level of specificity you want when you have a patent application drafted. So then we have the claims at the end. The claims in this particular application, we have 28 claims, which is more than what you typically get in an application. And this defines the scope of the invention. So this claim requires all of these components at a minimum for the invention. So what that means is when there's potentially infringement, your competitor or another person making a similar balloon sword, if you want to see if they're infringing, you compare it to what's in the claim, at least one claim. That's all that's needed for infringement. And then you kind of use this as a guide, as like as a checklist. Does this competing product or accused product have this? Yes or no? And if it has each and every aspect of at least one claim, then it's probably infringing. Now, the other person may have some defenses, of course, and say, well, no, this is not the equivalent of what's in here. It's outside the scope of what's in here. So there's a lot of back and forth with determining whether there's infringement. The main point, though, is to draft the claims within reasonable breadth to cover as much as possible. And so that's another strategy for why we have 28 claims here. So this is an example of a utility patent application that was granted for something fun like a toy. So very quickly, here's something that's more technologically or mechanically advanced. This is a folding bicycle. And this one has a lot more prior art that was cited during examination, as we can see. So we have the drawings here, all the parts, same setup. Start with the drawings and we end with the claims. And your patent practitioner is going to be the one to prepare all of this written material. This is not your responsibility when you're hiring a patent attorney. So I'm going to show you one that does not have any drawings. Usually drawings are required. However, this particular invention is a chemical composition. And so for this client, there really wasn't a need to have any figures because it's a formula. However, within the written description, I do have some chemical structures here just to serve as an example of what I'm talking about. And again, this is all drafted by me. We have the claims at the end. So here we have this checklist of if there's an infringing formula, it needs to have at least all of these things, such as what's in claim 1. Now I'm going to show you a different type of patent. This one is a design patent. So what we looked at before were utility patents that cover an actual physical product and the utility aspects of it. With a design patent, we still have an object. However, it doesn't cover the utility. It covers the ornamental features, simply the way something looks. So in this particular patent, again, we have the same first page, very heavily influenced with the drawings that shows all of the different views of the item. And you may think, well, wait, where's the text? It's not a very text heavy type of patent application. It centers heavily on the drawings, and you see we have only one claim here. However, these are deceptively simple. Deciding how to present it is very crucial, especially pertaining to the drawings. And these tend to be pending for longer than the utility patent applications because it's so detailed in considering each of the graphical aspects of what's presented. So I'm going to stop sharing. Okay. So that's my patent overview to kind of give you an idea of what a patent covers, how it's important in your business, and different examples of things that have been patented. And these clients that I've shown, they are commercializing their invention. They're making it, they're getting it into big box stores like Home Depot, they're getting on QVC. And without these patents, they would not be able to build their business. So it's a huge asset to have in your business. And that's why I work with these individuals and startups to get them to that point. And then it's just growth from there. So that's all I have today. If you have any questions, I'd be happy to answer them.
Thank you so much for that wonderful presentation, Ms. Mederos. There are a few questions The first question is it best to go with both a utility and design patent if both apply?
You can, yeah. It's possible. It's definitely considered on a case by case basis and budget. So that's one thing I didn't mention, and I'm sure a lot of you are curious about is how much does it cost. So I'll give some ranges. On the lower end, you have provisional patent applications for something of very minimal complexity, like maybe one object that doesn't have very many moving parts. Something like that is going to be in maybe the mid 2000s. And this is my pricing because I always include a search and I have a 10-point program that helps for success. I always plan for success. Um, Other practitioners may take a different approach, it may be less expensive, but with my approach, you get basically everything covered. Um, so low 2000s, all the way up to like that chemical one, it's probably about a $15,000 application. Most of my clients, however, end up spending between $3,000 and $5,000. So, of course, it's going to be on a case by case basis, depending on the complexity of your invention, what your budget is. Sometimes, if there's a possibility of a design patent and a utility patent, I may recommend starting with just a provisional and then claiming priority to that later on, doing one or the other. It gives you that extra year of time to decide while you still have patent pending status during that year.
Thank you. The next question, and correct me if I don't get your question absolutely correct, is from Miss White. She wants to know, what about a specific approach in therapy like intellectual property? Would that need, or is that more trademarking? Would that need a patent, I believe she's saying, or does that need trademarking? And Ms. White, please let me know if I did not relay your question correctly.
Okay, so therapies, it depends. If it's a therapeutic with a new formula, I would recommend looking at a utility patent for that. If it's therapy in terms of like a method of doing something and it's not connected really to any new object or use of some new object, it's going to be much more difficult to claim that in a patent application. Um, for trademark, yes, you can. I do recommend trademark use. And there's one thing that comes to mind, that yoga, it escapes me, but what is that? It's a popular yoga, Bikram yoga. So there is a registered trademark for Bikram. And so only those who are certified or have a license, same with Zumba, that's protected with a trademark. And those essentially are methods. And so a therapy is also a method. So I'd use that as a comparison. Patent protection wouldn't really apply because it's something that's abstract rather than tied to something that's concrete. But I think in that sense, for therapies, I recommend trademark route, um, using copyright registrations to protect your content because you're probably going to have written materials, maybe some video, maybe some audio. So I'd go that route. That's probably a better investment than going the patent route.
She said, thank you very much.
I
The
did
next,
have a question, and if I may ask.
oh, go ahead.
Of course.
Sure.
Yeah, so I read in Fortune magazine that IBM received the most patents in 2020, so I was surprised to see that.
Mhm.
But is there a way that we could track or find, maybe there's a sort of a resource or ways to know what might be coming up for future patents?
Um, yes, in the official gazette that's published, I think at least every month, by the USPTO, we get a list of what's coming out. But I will tell you that IBM is focusing a lot more on artificial intelligence and machine learning. They've put a lot into that, and I think that's what I've seen coming out from them the most. There are companies that do patent analytics, and that's something that's really useful to medium to large size entities that need to keep track on the industry, keep track of the key players in the game. That's not something that I keep track of. I do manage portfolios for my clients, but I don't really do any analytics of who has what and when it's coming out.
Thank you. The next question is, has it been more difficult to obtain a patent because of COVID-19? And if so, how?
It hasn't been more difficult in terms of how the patent claims are being examined. However, the time that it's been pending has increased. Yeah, same with trademarks.
All right. The next question is, what is the error that you see more often than not on patent applications that you see other people making?
Errors. I think the biggest error is those who try to DIY or use LegalZoom or one of those companies, and what ends up being in their patent application. Yeah, you can put whatever you want in there, file it, get a filing date, get an application number, get patent pending status, but it doesn't protect anything. And so when that happens, you've been disclosing your invention this whole year. And then when it's time to do the non provisional application, you can't because you just became prior art against yourself. And so you're barred from getting a patent granted. So that's the
Wow.
biggest error.
All right. Just two more questions. Does a patent always afford protection?
It affords protection based on what's claimed for as long as the patent is active. So once a patent is granted, there's also going to be some maintenance fees that are due at the 3.5, 7.5, and then 11.5 year marks. And the reason for that is because if people are not commercializing their technology, not using it, then it should go to the public domain. So maintaining the patent is important. So as long as you have that and you have what you need protected in your claims, you're good.
All right. And the last question is, what benefits for small businesses who obtain a patent outweigh the costs? Because I know some small business owners may look at the cost and they may think that it's not worth it.
Yes, that's a great question. And believe it or not, there are some clients that come to me and I will straight up tell them I do not recommend moving forward with a patent application. And they're like, what? But you're a patent attorney. I'm like, yeah, but that's not what's best for your business. And so, yeah, that's another case by case, specifics of what the business plans are, how you can better commercialize or protect your IP, like in the case of the treatment. Patent protection may not be the best route, may not be the best use of resources. So yeah, it just depends if and what the key players are going to want, what's how it's going to affect fundraising. If it's something that's just a method or something that's more of a trade secret, it's probably better keeping it as a secret rather than going the patent route.
Very good information. That's vital information. So once again, thank you so much for taking time out of your day to present during this webinar. If anyone wants to get in contact with you, do you have, are you able to provide your contact information, please?
Yes, yeah. If you'd like, you can go to my website, mederoslegal.com. It's my last name, Mederos legal.com. And right on the front page, I have my calendar. You can pick a time that's available for you. It's a free 10-minute slot with a call directly with me, nobody else, and we'll get you set up and put a plan of action together.
Great. Thanks again, everyone, for your time. Everyone stay safe and healthy. Goodbye.
Thank you all. Bye.